Ready, start. High Court has failed to appreciate that amendment to the Punjab VAT rules applies only to the rate of tax prevailing on the date of sale of the stock in trade and therefore does not affect the rights of a dealer or the ITC on the transaction which stood concluded. Full stop. Learned Counsel has referred to the rule making provision in the Punjab VAT Act, that is Section 70. Full stop. However, he concedes that as per the proviso thereto, the rules shall be made with retrospective effect only if the same are required to be made in public interest. Full stop. He finally submits that state has a larger affirmative responsibility towards the society. Full stop. The impugned provision may be examined from that perspective also. Full stop. Per contra, learned counsel for the respondent submits that High Court had rightly observed that on the date of introduction of sub-rule within bracket 8 in Rule 21, the state did not possess any power emanating from the Punjab VAT Act to confine the availing of input tax credit to the reduced rate of tax on the stock in trade, that is on the transaction which stood concluded with the dealer already earning input tax credit at the previous higher rate of tax. Full stop. He submits that a perusal of the amendment in the first proviso to section 13 within bracket 1 of the Punjab VAT Act would reveal that the said provision is not retrospective but applies to transactions after 1/4/2014. Full stop. The amendment in the said rule, which came into effect prior to the amendment in the Punjab VAT Act, could therefore not be enforced by the appellant before 1/4/2014 to take away a vested right already determined and accrued to the respondent without any statutory sanction. Full stop. Learned counsel for the respondent contends that the limited issue in this appeal is whether Rule 21 within bracket 8 of the Punjab VAT rules could have been introduced and made applicable during the period between 25/1/2014 to 1/4/2014. Full stop. In that context, Learned Counsel contends that on the date when Rule 21 within bracket 8 of the Punjab VAT rules was introduced, there was no enabling provision in the Punjab VAT Act that empowered the state to reduce the rate of input tax credit already earned by reference to the sale of goods lying in stock. Full stop. The statutory position is clear in that input tax credit would be earned on the date of purchase in accordance with section 13 of the Punjab VAT Act as it stood on that date, that is on the date of purchase. Full stop. Amendment to the Punjab VAT Act empowering the state to notify such a rule came into effect only on 1/4/2014 when the first proviso to section 13 within bracket 1 of the Punjab VAT Act was amended. Full stop. The words single inverted comma are for sale single inverted comma close appearing in the first proviso to section 13 within bracket 1 were deleted and substituted with the words single inverted comma are sold single inverted comma close full stop. Similarly, the words single inverted comma for use in the manufacture single inverted comma close were replaced by the words single inverted comma are used in the manufacture single inverted comma close full stop. Effect of this amendment was to limit the input tax credit earned on the goods already sold or used in manufacture. Full stop. This amendment therefore enabled the state to reduce the input tax credit already earned on the stock in trade by reference to the reduced rate of taxation. Full stop. State of Punjab introduced Rule 21 within bracket 8 in the Punjab VAT rules via the notification dated 25/1/2014. The effect of which was that though the respondent would have paid tax at the existing higher rate on the purchase of raw material used as input, comma, it would not be in a position to recover the whole of it from the customers because of subsequent reduction in the rate of tax. Full stop.